All right. Good afternoon, everyone. Thank you for joining us today for this next series in the Navigator webinar. Thrilled to have two industry experts join our panel. Excited to turn it over shortly to them for introductions. But first, I'd like to thank our team at Sales GRC that worked in putting this presentation together, and for the speaker buying timely and interesting topics that we know our clients and the rest of the industry are quite interested in hearing about. So with that being said, I'd love to first turn it over to Anne and then Mike for introductions so they can talk a little bit about their practice. Yes.
Thanks, Peter. I'm Ann Cho. I'm a partner at Wilkie Farr & Gallagher. I'm based in our Washington, D.C. office. So my practice is in the Investment Advisors Act world, and then also the Investment Company Act. And a large part of my practice is helping our clients handle and navigate SEC examinations and potential enforcement matters as well. Really glad to be here.
Thanks, Peter, and thanks, Ann. So my name is Michael Merrigan. I'm the founder of Shadmore Advisors. We're an operational due diligence consulting company. We've been in business for a little over 10 years, and we work with allocators to alternative investment managers to help them identify potential operational risks, remediate those, and potentially monitor those on an ongoing basis as well.
Perfect. Yeah, and I think having Ann and Mike and their expertise, I think, is quite invaluable, and also where they sit in terms of the role that Ann plays advising clients, but also from a different perspective, although nevertheless still focused on the registered investment advisory space that Mike sees and comes across every day. So I think collectively those opinions and guidance and thoughts that they're going to share with us is going to be quite helpful. Finally, my name is Pete Wilson. I'm the COO of Sales GRC, which is a compliance regulatory consulting firm. We also do have a cybersecurity practice. I am an attorney by training, began my career as a prosecutor, have been in-house at a number of firms as a prior to joining Sales GRC. I was head of U.S. compliance consulting at a firm called Duff & Phelps, which is now known in the market as. So thank you again for joining us. And I'm going to quickly flip now to our agenda. So we're I know we initially said that we'll be talking about SEC exams and expectations, but I think there's been a lot of recent developments, whether it is with the SEC priorities, some rulemaking, or even, frankly, the general election that happened last week. Want to spend a couple of minutes with this panel talking about their thoughts on that. But then we're going to transition to preparing for your next SEC exam, some ideas and recommendations that we have to share with all of you, trends that we're seeing in exams, and then also procedurally walking through an exam. What is your first interaction with the staff? What does that look like? And then what will it look like once the exam kicks off, and then ultimately how it wraps up. And then there are a couple of other related topics that we wanted to talk about. There is a Q&A that you will find in this on this platform. So this is really designed to ensure that we're providing helpful guidance to all of you. So to the extent that you have any, please feel free to ask those questions. So as you all know, at the end of October, the SEC published their 2025 SEC exam priorities, as well as the outreach which recently occurred. So I think the first question would be just to Mike and Ann. What are your observations from those priorities?
Yeah, I'd be happy to take that one. So the exam priorities are published now in October. So the first time that the SEC staff did that was last year, and they intended to do that to align with their start of the fiscal year. So I think that's really intended to signal for registrants to understand what their focus and their priorities will be actually for the coming year in the examinations front. There's a lot in the examination priorities, much of which is very similar to the 2024 exam priorities, but I think there are a couple key takeaways and new changes that I had noticed. So one of the few interesting points relate to conflict. So I think conflicts of interest and understanding, identifying, and mitigating conflicts is one of the trickiest parts in a compliance program for investment advisors and investment managers. This exam priorities that was just published provides a little bit more detail actually on how the SEC is going to focus on conflicts of interest. They highlighted particular areas around fiduciary obligations on outsourcing investment management functions. They also highlighted conflicts around alternative sources of income, and then the appropriateness and accuracy of fee disclosures and conflicts related to fees. So I think that's important to take away. Under the fee-related conflicts, they also added something new related to pulling out select and certain clients that may be receiving a preferential fee arrangement compared to other clients. So something to look out for. In the private fund area, not surprisingly, I think the exams will continue to focus on the private funds. The report provides additional detail around disclosure of conflicts, disclosure of fund level subscription facilities, advisor-led secondary transactions, investments in multiple funds, transactions across funds. So I would just encourage investment advisors to focus on the legal compliance team members that are on the ground with the investment teams, and that's sort of the front line in actually identifying and mitigating conflicts of interest.
Okay, great. And one other area that I think was interesting that we've seen the SEC talk about and has found its way into the priorities is AI and managers using AI, disclosures associated with it. And so obviously as part of any updates to offering documents as well as ADV disclosures, we're thinking about how our practices and use of AI reflects that. But what's your reaction to that, and what are some of the things that that managers should be thinking about?
Yeah, so we've actually started to see certain deficiency comments around AI and use of AI in examinations. And the exam staff is focusing on artificial intelligence related to large language models, generative AI, and whether or not those technologies would impair or have some kind of influence on the investment decision-making process that you're not otherwise disclosing to clients. Another aspect of AI that I think is really interesting relates to sources of MNPI. Is the model intaking MNPI that could potentially affect your trading, and should it cause kind of restrictions on trading? So we're already seeing kind of trickling in comments around AI usage.
Terrific. I think, one observation that I had, and this is something that the staff has been talking about for the past number of years, is their focus on new registrants and their interest in wanting to registrants sooner in the process. And, frankly, I know the SEC has spoken about that for a number of years. I would say over the last few years, we have actually seen that play out there that are participating on this webinar. Our experience and our expectation as we're advising 12 to 18 months, I would expect outreach from the staff. Now, whether it's a comprehensive exam or a lighter touch exam, you don't necessarily know, but Ann or Mike, what has been your experience when it comes to the new registrant exams?
That's the same that we've been experiencing. We've seen the staff come in anywhere between 6 months of newly registering with the SEC to 12 months is very common at 18 months. So I would completely echo your thoughts, and that you would expect to get an examination pretty much very soon. And the new exam actually could be quite challenging because you may not have a lot of operations. You may be tweaking your compliance program, and I think that's okay. I think the exam staff does understand that in connection with the ramp-up phase, there is some enhancements that could be made in connection with the compliance program. Of course, your compliance policies and procedures should be up and running effective on day one, but I do feel that there is a little bit of a ramp-up period that they do understand.
Yeah. And I think as we'll be talking about as we move this conversation to exams, expectations of exams, it is a risk-based approach. And so one of the first data points that the staff will utilize when conducting that risk-based approach is, besides your regulatory filings, is your initial examination into your culture of compliance program that you've initially rolled out. So it is an important first interaction that you will have. But I would love to just shift momentarily and talk a little bit about the national election and the impact that may have on rulemaking, on perhaps the leadership of the SEC. What are your thoughts on the impact that will have in this industry?
So with the new changing in the administration, we are expecting that the rulemaking front will be significantly slowed down. We are not expecting any of the proposed rules under the Gensler administration, any of the substantial ones, to actually move forward. So for example, still outstanding would be the predictive data analytics. That was supposed to be re-proposed anyway. We don't think that's going to move forward under Gensler currently. That goes the same with the amendments to the custody rule / new safeguarding rule, and also the outsourcing rule. We're not hearing that that's actually going to move forward, and we'll see what the new administration comes forward with. In terms of the private funds rule being struck down, I think that was sort of phase one. The SEC did kind of step back and needed to reevaluate the litigation risk in connection with a lot of the rulemaking. So again, custody, outsourcing, predictive analytics, ESG for funds and advisors, unlikely to move forward. But one interesting theme that I think will play out in connection with examinations, I don't think that's going to change too much in connection with the examination priorities. The exam staff is usually they have over 1,000 examiners. So with the ebbs and flows of the administration, it might be tweaked on the margins, but this is going to be significantly, I think, the plan going forward for 2025. So a few additional points that I wanted to highlight for the examination priorities. They focus on, again, the outsourcing of investment management. The outsourcing rule, I don't think it's going to go forward, but there are a few nuggets around the exam staff focusing on outsourcing. So I think that's one area to look out for. Another area would be going back to private funds. So PFAR being struck down, I still think the examinations team is going to focus on disclosure of conflicts again, disclosure and calculation of fees and expenses. They also pulled out nuggets around commercial real estate, illiquid investments, valuation. Those, I think, will continue to be a focus of the exam staff.
I think, Peter, one of the other topics is crypto, I think, too, and trying to understand
That's
what are the
helpful.
ramifications for that.
Yeah, please go ahead.
I was just going to say, I think that, the crypto space has been sort of mixed in terms of, obviously a lot of changes in that space, but interest in that space. And then there was some trepidation as sort of, FTX and things like that had happened. But there does seem to be some ongoing interest in it. And I think that a lot of people are looking to see what the future regulatory stance on that will be. Maybe the Trump administration seemed to signal that there might be some more interest in trying to push that further than it has so far. So I think that'll be an interesting thing to look at as this evolves.
And although I think examinations will continue its course, I do think there's going to be a shift in the enforcement focus. So hopefully there's going to be less of a broken windows approach to enforcement. We're likely going to see less off-channel communications issues, less enforcement actions that did not have any actual harm to clients or investors. So I do think there's going to be a shift in enforcement, but hopefully the deficiency comments in examinations will stay within exams and not get referred over to enforcement.
Okay, terrific. Yeah, so I think what we're hearing is perhaps policy-wise and enforcement, we may over time see an impact. However, the routine examination and the focus of the staff will generally remain the same. Would love to get your thoughts on this, and I think you've touched on some of this already, Mike and Ann. But updates on rulemaking. Any particular rule here that you want to share some thoughts on?
So one note about cybersecurity and amendments to Reg SP, the SEC did propose rules related to cybersecurity for funds and advisors. We're not anticipating that that's going to get finalized. It may, but it seems unlikely at this point. But they did adopt amendments to Reg SP. So those amendments were adopted back in May of 2024. And I just did want to highlight for the audience today that these amendments would require advisors and funds to beef up their compliance program in sort of three ways. There would be a requirement to adopt, implement, and maintain an incident response program. There's also a new requirement to notify customers if there's a breach of their information within 30 days. And then it also imposes new service provider diligence and oversight requirements. So unless the Trump administration kind of pulls back the rule, Reg SP will need to be complied with. I believe for large entities, the compliance date is going to be beginning of 2026, February of 2026.
Pete, on the service providers, I was just going to mention. Sorry, I was just going to mention that there was the potential, I think, for the SEC to be potentially more prescriptive about that going forward. But I think that what we're seeing from, this comes up in our operational diligence reviews, is that investment managers are starting to really get very robust about having a ongoing service provider due diligence process, a hierarchy of risks that determines relative frequency of these types of reviews, and in many cases, outsourcing this to a cybersecurity consultant or another group to potentially assist with that. And some of the really large enterprise managers have this as a completely in-house, built-out standalone role. So I think that's going to be with or without further guidance from the SEC. I think that's going to be something we're going to continue to see, largely just because so many functions at investment managers continue to be outsourced.
Yeah, I think that's a great observation. I would say if frankly, up until this proposed cyber rule, the SEC, while they may point to Regulation SP, they began their focus on cybersecurity back in 2014 with a risk alert, and from there, institutional investors started to grab a hold of that concept. And so, Mike, I think you've been seeing part of that play out right over the last number of years, because these LPs get a hold of these concepts. Even if it's not a final rule, nevertheless, it's built into how they're looking at managers. And so whether it's a cyber rule or even the service provider due diligence rule, where we're seeing managers be quite proactive in, frankly, adopting many of the concepts that we see in that rulemaking. But let's take, though, Mike, just briefly, the private fund advisor rule that ultimately the Fifth Circuit vacated. There were concepts in there about expense disclosures, enhancing disclosures to your LPs. Have you seen at least some of those concepts similar to perhaps the guidance the SEC has given on the cyber rule back in the day? Has that gained some traction?
I guess my observation is that the private fund advisor rule was a fairly significant concern to people before it was thrown out by the court, and there were many concerns about how to adhere to it. And I think that once that news came out, it was quite a relief. I don't know that many funds, to be honest with you, are actively or proactively trying to implement any of the guidance that was in the law on a voluntary basis. I'd actually be interested to see what Ann thinks about that.
Sure. So we have not seen that as well. I think we have heard of folks potentially evaluating and expecting some of the larger institutional investors to sort of demand more information in connection with the quarterly regular cadence of investor reporting. But in terms of the private fund advisor rules related to the disclosure of the fees, expenses, and side letter arrangements, we have not been advising and have not seen that kind of come to fruition.
Okay. Terrific. Yeah, I would end by saying I think as a, one observation that we have from where we sit as it relates to service provider due diligence. I think historically service provider diligence was viewed, at least the formality began with cybersecurity and conducting information security. I think where we've seen the market go and what we're quite focused on advising clients on is that it's actually a more when it comes to information security is a critical component of that, but there's a number of other areas that you should be focusing on.
I think if I can make one last observation, that Peter, is there's an increased interest in fourth parties as well. So in other words, your vendors and your vendors' vendors are the fourth party, and figuring out how you're going to do vendor due diligence on those in addition to your direct vendors.
So we're going to transition now to a little discussion on preparing for your next SEC exam, but we do have a number of audience questions that we would love for you to complete. So if you can all just take a quick moment to answer this question, and once you do that, we'll go ahead and we'll show you the results. I think this is a question that we get fairly often from our clients is, when should we expect an exam? What is the frequency of exams? So getting this color from the audience, I think, will be helpful. Give it another second here. Okay, so here are the results. Perhaps that last one is most interesting. But and Mike, any reaction to that?
I would just say that this sort of coincides with. This is a small sample set, but I think it coincides with the larger. Many managers are not having frequent SEC exams, and if you just reached out to a garden variety general manager, investment manager, it probably has been years since they were last reviewed, especially if they're not a new registrant. So these numbers actually, I think, make perfect sense based on the observations that I see, month to month.
One interesting point about the exam priorities from this year, I believe they no longer publish some of the statistics related to the coverage of the examinations, and that may be because the percentage of exams that they're doing is actually going down. And then instead, they're really emphasizing the risk-based approach of selecting investment advisors. So again, it really is going to be based off of your risk profile, of your size of the firm, the size of the AUM that you're managing, whether your strategies are complex or a little bit unusual. That's going to increase your chances of an examination.
The next question that we wanted to poll the audience with was, how long did your most recent SEC exam last? And again, another common question we get is, we're just notified by the SEC, what are expectations for when this exam should wrap up? So was it less than 60 days, 3 to 6 months? Or in some instances, it drags on for over a year. So would love to poll the audience so we can share that with the entire group here. So we'll give this 15 seconds. And Anne, perhaps as people are completing this question, what would be your reaction if I'm a client that's calling you saying I've just been notified, I'm a routine exam, so nothing out of the ordinary, not a sweep exam. What would be your thoughts there?
So I often caution our clients if they're getting notified of an exam, it's typically not going to be a one and done deal where you get the initial request list, you respond, and it's going to get wrapped up. The expectation would be that it could take a very long time. There are certainly many examinations that we've worked on that have dragged on, unfortunately, for over a year. It's pretty torturous. And then the timing of the request is not consistent. You could have a request come in, your turnaround time is very quick. You may not hear from the exam staff for a month, 2 months even, and then they come back with a flurry of follow-up requests. So it's very unpredictable. I think ideally they get wrapped up in more common. I'm guessing it's going to be between 6 and 12 months is what our audience is going to come back with, but there are a number of examinations that drag on for a long time.
Pete, I was going to say that one of the interesting things, and I agree with Ann, is that we often ask clarification questions. So what year did the SEC exam happen? And you're hoping it's like a number like 2022, 2023. But in truth, it actually started in a certain year, maybe halfway through that year, and it ended in the next year. And so it's often difficult to put it into the space of a calendar year because they do tend to go on for in excess of 12 months sometimes.
Yeah, and so just perhaps a reaction to this response over 1 year, over 16%. So as you both pointed out, these can drag on. It doesn't necessarily mean that the exam is trending in a terrible negative way. It's just sometimes the nature of these exams, and so it's sometimes hard to read anything further when it comes to the cadence for which the staff is engaging with you, because could have just kicked off a number of exams at the same time that they launch your exam, and then there's workflow that they're personally managing, which you may not be obviously aware of.
And the scope of the exam would often kind of drive the timing as well. There are a number of sweep exams that are happening right now. There's one going on to focus on the custody rule, for example. There's another sweep on T+1 implementation. The more narrow focused sweep exams typically go faster because there's a more narrow set of requests and they want to get those done, and they have a lot of managers that they're going through. So in our experience, those are typically quicker.
Yeah, and that may be the less than 60 bucket that we're seeing almost 12% there. But now transitioning to preparing for your next exam. So there's a number of topics on this slide that I would love to explore with Ann and Mike. And many of these are driven by conversations that we have with our clients when they're notified. The first question that we typically get is, what role does counsel play? How should they be advising us? How active should they be involved? So would love, Ann, some of your thoughts on that.
Sure. So I don't mean to sound self-interested, but I think counsel can play a critical role in connection with an examination. We have had, and I think it creates, having counsel plays an important role in protecting important strategy discussions in connection with the exam, particularly if it's going in a bad direction. So what do I mean by that? So if counsel is involved and we have communications, emails are flying back and forth, chats are going back and forth internally. If counsel is not involved, those communications will not be protected by privilege. So if an exam kind of goes south, it gets referred over to enforcement. The enforcement staff, in connection with their investigation, they are often inquiring about communications related to a particular topic, and it could bleed into what happened during the course of an examination. And so we have seen situations where the enforcement staff is focusing on those exact emails and communications around the examination, whether there's bad faith, whether there's misleading kind of allegations around internal staff potentially misleading the examination staff. If legal counsel is not involved in connection with the examination, then those communications would not be protected and you would have to potentially produce that to the SEC. More generally, if it's a routine examination, I think counsel can play a critical role in kind of managing the exam. We can help with all the productions. We can help with making sure that the information that you're producing is sort of middle of the road, in line with what the examination staff would expect to see. The other thing is related to FOIA. So the SEC has a particular rule, SEC rule, I believe 83, where if you want to protect the information from being FOIA from a public perspective, you would have the information kind of bait stamped and protected with that information, and we can help with that process as well.
Terrific. I think, one topic that I do think is important as we prepare our clients for their next exam is thinking about testing and the implementation of that testing. And what I mean by that is this is a risk-based exam that the SEC staff will conduct, and they're going to come in, and one of the first questions, and perhaps this is leading into the day one talk about momentarily, but they're going to ask for you to discuss what is your inventory of risk. So they're asking you as a manager to identify those higher, those moderate, and those low risk areas. Ultimately, they're looking for symmetry as it relates to those higher risk areas to see that there's testing that reflects the higher risk profile that may have with your business. So when the examiners do come in and they start talking to you about risk areas, ultimately, though, they're looking for you to substantiate your focus on those risk areas by the testing that you're conducting. So it's not something perhaps if expenses is a high risk area for you, they're not expecting to see you conduct expense testing once a year, but rather that you may do it quarterly, that you may do it monthly. It's also not static. And so as your business evolves and as perhaps new clients, new funds come on board, that changes your risk profile. And it's important that your testing program also adjusts accordingly. As it relates
I was going to say one thing I was going to say on the test and implementation is that the testing also should in some ways correlate with prior SEC exam deficiencies. So if, for example, your allocation of expenses, for example, was problematic last time, that would probably be as an effort for your remediation and going forward, that part of your testing would be checking that more often than maybe you did before that deficiency. So a lot of the, I think that, not a lot, but a decent amount of the testing, I think, in addition to being risk-based, is also should be based on where there's been sort of foot faults in prior regulatory examinations.
Great. I think a critical part of being prepared for an examination, and obviously testing and the annual compliance review and the periodic training that takes place with your employees, all of that is obviously quite important. But we do get questions fairly often about a day one deck or day one presentation. And by that, I mean a presentation that you would share with the SEC staff at the kickoff of an examination, where you discuss with them the compliance and regulatory risks that exist, but more importantly, the mitigants that you have put in place and the controls that you've put in place. And what have you seen in the market as it relates to day one decks, your thoughts on having that ready to utilize?
We are generally seeing folks continue to prepare day one decks. For example, it's very common in connection with the new registrant examination. Obviously, that's going to be the first time that the SEC has exposure to the new registrant, and I think it's well received from the examination staff. The other type of area would be if there is a unique kind of fund structure or business. Oftentimes the SEC would want to get a better handle of the business structure, and then they often are very appreciative of the day one deck. You may not need a day one deck if, for example, it's a sweep examination focused on a particular area. The exam staff is sort of in there. They want to get the information that they need. And in that context, you may not need one. Another scenario where a day one deck is probably not needed is if you're a large, well-known, established asset manager and you routinely have to deal with SEC examinations. The exam staff knows you very well. You likely will not need one. But general practice, and we generally do advise, go ahead and prepare one. It's great to have one in a can, ready and connection and prepared for an examination.
Yeah, and I would say, as it relates to the day one deck, in my experience and the advice that we typically provide to clients, even if the staff has not asked for the manager to conduct the day one presentation, we'll ask for is an initial hour and a half, 2-hour phone call with the CCO and perhaps the portfolio manager, where you'll have an opportunity to actually share that presentation. So I highly recommend that you take that as an opportunity to at least spend the first 15 minutes, 30 minutes walking the staff through it, where you're, again, highlighting your compliance program. You're talking about those risk areas that exist because, frankly, they exist at every investment manager. And to hide from the staff that you don't think you have any regulatory risks is simply silly. But rather putting them on a deck and sharing them with the staff, and more importantly, talking about how you mitigate those risks is very important. We did get a question that just came in, and I'll share it real time. And the question is, and I'll throw it out to Mike and Ann, what type of controls and documentation does the SEC expect for private equity and private investments? How to comply aside from having an audit?
Sure, I'd be happy to take that one. So if the manager is fully registered, subject to the custody rule, all the assets of a private fund or an investment management agreement, if the advisor is deemed to have custody, would need to be held with a qualified custodian. So in the private fund context, if the investments in the private fund are underlying private equity or private investments, you would either need to keep them at a qualified custodian or be able to rely on an exemption from keeping them from a qualified custodian. So in the course of an examination, how this plays out is you'll often get a request for all of your underlying private investments. Explain to us how you can qualify for the exemption from having to maintain those assets at a qualified custodian.
Okay, terrific. I think one question we get a fair amount from clients is a mock exam. So not unusual for managers to think about having a mock examined by the SEC in 3-4 years and think there's some good hygiene that comes with a mock exam. So, one, I'd love, Ann, to hear your thoughts as to the value of a mock exam, but two, also, Mike, your thoughts as it relates to when you're conducting diligence, your analysis that you and the weight that you put on those mock exams as it comes to the work that you're performing.
Sure. So we, as operational due diligence personnel, I think we were very much big proponents of it. We appreciate when managers have taken the time to do that by engaging a compliance consultant to potentially do that, or their counsel. We think that, especially for smaller managers, going through an SEC exam when you haven't had that experience before, and not being fully prepared for it is potentially challenging in a lot of ways, especially while you're trying to maintain the running of the business while you're going through the exam. And also, we find that by going through those mock SEC exams, you are also better understanding of what is going to be required of you, and therefore more likely to have that when it is required of you, which is sometimes is at a moment's notice. One of the things that is an interesting nuance to it that comes up is if you have a dedicated compliance consultant that you're using, for your testing or your manuals and things like that, is whether that compliance consultant should also be the one who's doing the actual mock ODD, because essentially it could be, unless there were different groups within a big firm, the same people could be testing themselves in terms of the ones that outlined the original compliance program. So sometimes there's some debate about whether a third party should do that or a different compliance consultant than the normal one that's used. But overall, I think the mock SEC exams are very important. And the feedback we've gotten from managers has very consistently been that, even if they didn't hit every single thing, they felt they entered into an SEC exam in a much more confident manner than they otherwise would have.
I completely agree. One comment that I would add on mock examinations, we often encourage our clients to obtain a mock exam from a compliance consultant, but it would be in connection with the role of counsel, whether or not you want to engage the compliance consultant directly on behalf of the client, and that would help to maintain privilege for some of the communications in connection with the mock examination. For example, if at the end of the result you have a written report from the compliance consultant, if you're going through earlier drafts of the report, if you're doing it through counsel, you can kind of protect privilege before you're completely satisfied with the final results of the report. Because in connection with the real examination, it's often a standard request for the SEC to ask for the mock examination report.
Great. And I would say, in all terrific feedback, I would say in my experience, interview preparation and what we learn from our employees when we interview them over the course of an hour as we explore different areas of their day-to-day functions and their knowledge of the compliance program and the risks is quite insightful. And you learn a lot about your team and making sure that they're well prepared for that exam if and when it does occur. We do have another question or polling question that we've put up, which is, have you conducted a mock SEC exam within the past 24 months? And I think this is an interesting question for the audience to simply know the results of where you may stand amongst your peers in terms of SEC preparedness. So if you all just spend a second to answer that, I'll share the results in a moment. Okay, let's see what we have. So over a third have conducted a mock within the past 24 months. And then there's always that handful of managers that have been examined. That certainly does come up from time to time where they actually didn't need a mock exam because the real one happened. So some interesting data points there. And then the final question before we move to trends in exams is, do you have a day one deck ready to go? So we talked about the importance of that. And so you may have one that you prepared a number of years ago. So perhaps it would be helpful for the audience to share with their peers where they are so you can assess your preparedness for that.
I often get the question, who's going to do the actual presentation for the day one deck with the SEC? I like to lead off with the investment team or one of the principals. They are accustomed to marketing the funds or marketing the investment management services. Of course, interview prep is critically important, but they often are involved in that. And then also the CCO and the CFO would have a role to play as well once you get into the compliance controls and framework.
Great. I also think, and to your point, in many instances, it's the portfolio manager perhaps is also the founder of the firm. And I think from a tone at the top, demonstrating to the staff how important the firm is taking this examination, having one of the founders as part of it certainly suggests that to the staff. So Not terribly surprised by this, with the largest majority being have one, but it's a little dusty. I think what is a good practice, that I recommend is if you have one that is dusty, use the annual review process. So your 20647 has a great way to at least once a year dust it off, update it. So then you at least know that within the past 12 months it has been updated. So the 20647 is a great time of year to reflect on that. So trends in exams, would love to briefly turn this over to Anne to talk about some of these topics. I know we have about 15 or so minutes to go. Would also love Mike to get some of your thoughts as to how these trends also impact the way you conduct diligence on managers, how it informs your areas of focus.
Great, thanks, Peter. I'd be happy to go through sort of the list of hot topics. So it's on the right-hand side of this slide here, and I'm just going to quickly go through what we've seen in the last sort of 6 to 12 months in connection with examinations. Marketing rule continues to be a really hot focus area. We have seen the exam staff roll in or fold in standard marketing rule related requests directly into the standard request list. They are focused on, in terms of the marketing rules, general prohibitions, no materially misleading statements, statements that are fair and balanced. I would insert ESG, AI disclosures in sort of the general prohibition. So as part of your marketing rule, really make sure that your ESG and AI statements are fair and balanced, you have substantial support, you are able to substantiate the information. The SEC is really pulling out particular phrases and asking for the substantiation of any material facts. Testimonials and endorsements under the marketing rule, they are looking very closely at social media posts, social media influencers, and seeing if those are complying with the requirements under the marketing rule around the disclosure of whether compensation is paid, whether or not the information is made clear and prominent together with the actual statements that could be viewed as an endorsement. So they're getting very nitty-gritty on that. Other areas of marketing rule would be third-party ratings. If you have a third-party rating posted in an advertisement, we're going to want to make sure we're including the disclosure requirements. And then the actual approval, the compliance approval of all advertisements. If you don't have a CRM kind of tracking the CCO approval of advertisements, it could be pretty painful to kind of pull out all the evidence of the approval. So that would be a good way to prepare for an examination, making sure that you have that substantiation for the actual approval. Custody rule. So again, I mentioned there's a current sweep around custody rule compliance. Basic tackling and blocking around custody rule, making sure that the private fund audits are being done, that they're being done timely, that the audited financial statements are being delivered and provided notice to investors of the delivery. And then for separately managed accounts, making sure that advisors have assessed whether or not they have custody, and if they have custody, if the assets are maintained at a qualified custodian, and then if the custodian is delivering the statements, and then whether or not the surprise examination is being done correctly. MNPI, here we have a bullet point, enhanced focus on MNPI and sources. So in the area of private equity, we are seeing a more intense focus on MNPI. And so a default position of the SEC exam staff would be if the private fund manager is signing a non-disclosure agreement with a potential portfolio company and there's a public issuer in the mix, for example, they are expecting the public issuer to be included in the restricted list. And if it's not included, an explanation about why the information may not be material. Other MNPI sources would be the latest enforcement action that was brought against Marathon and participation on ad hoc creditors committees and whether or not there is MNPI risk related to that participation. Use of AI. So we talked about that earlier in the presentation, which would be understanding the disclosure that you have in your marketing materials around AI and whether that's consistent with your actual investment process, the risk related to the use of AI. Are you disclosing the actual risks appropriately? compliance policies and procedures around AI. The exam staff is asking for any information around your compliance framework around the use of AI. E-coms, we are, a note about e-coms would be, given the change in the administration, we are expecting the cases that have been around e-coms to potentially be wrapped up, but the new administration likely will not focus too much on e-coms. But that being said, I think it would still come up in connection with examinations, whether or not you have off-channel communications happening at your firm. Code of ethics, so outside business activity. One common theme that we continue to see in examinations is canvassing your outside business activities of your personnel. The exam staff has a trick, I guess it's not really a trick, but they'll go on public websites and understand and try to ferret out outside business activities of the founders and the principals, and making sure that the disclosure or conflicts are being appropriately mitigated. Cybersecurity, so enterprise and regulatory risks related to cybersecurity, and circling back to Reg SP, we will expect, once those amendments go into effect, that the exam staff is going to focus on compliance with the new requirements. And then the perennial issues around fees and expenses. For private fund managers in particular, we have seen an intense focus on the calculation of the management fees, the calculation of any offsets to management fees in relation to the receipt of other fees and whether or not it's offset against the management fee. So we do expect a continued focus on fees and expense calculations. And then the final point here would be corporate meetings and use of expert networks or other research providers. So we often see a focus in examinations if you're using an expert network, if you're using a research provider, whether or not the advisor has conducted due diligence over those third-party service providers, understanding the risk of receiving MNPI, and whether compliance is shepherding those meetings. Are they getting documentation of the information that's being conveyed? Are you meeting with representatives of public company executives? So those are all things that we continue to see in connection with exams.
Peter, what I was going to just mention is that this is a great list, and I think that these are the topics du jour. You know that from the SEC guidance, but you also know from just talking to managers and going through their deficiencies over the last 6 months or 12 months. Operational due diligence practitioners, I think when they meet with CCOs, which they almost always do, they want to make sure that they have an awareness of these policies or these topics and policies to basically mitigate risks related to them. And I think that the CCO's ability to speak very sincerely and in depth on these types of things is really provides a lot of confidence to folks, because you're always going to be worried about your foundational topics like personal trading and things like that. But a lot of these things are topics that just weren't really, interesting a few years ago. And so I think this is very, dynamic, and I think that it's really important for the CCOs to be on top of all these things, because that's what ODD practitioners are looking for, is to make sure that managers are getting ahead of these things, looking at what other people are going through in the industry, and making sure that their firm is not going to be subject to similar challenges that their peers have gone through.
Yeah, and I don't think any of the associated questions that the staff would ask you on these topics tends to be unique or novel. I think if you were to ask for your compliance consultant or for Anne to share some standard doc request list, you're going to see how the SEC is analyzing these types of areas. I think what is potentially problematic is the answer that you may share. So, for example, corporate meetings and use of experts, pretty basic standard question. The problematic answer would be that compliance is not tracking those corporate meetings, doesn't have visibility to the investment professionals' calendars as it relates to those meetings, that you're not taking a risk-based approach when joining an expert network call. So really it rests in the answer itself and not necessarily trying to figure out how the SEC may pose those questions to you.
I think one of the best ways to describe this, I think, is that whether a manager is going through an SEC exam or whether a manager is going through an operational due diligence exam, the goal should be command over the facts. And being able to address every single topic, having the knowledge about it, being able to explain how your policy works, that's the sort of target for excellence, I feel like. And obviously there's a lot of varying degrees around that, just because there's so much in this category.
So I know we're approaching the 2 o'clock hour. We have a few minutes left, and we have a few more important topics to get to. So I'm going to quickly pass this get to some. Perhaps we can talk. CCO should expect. What is the turnaround time for the initial doc request list? Is it okay for us to ask an extension of the staff a document?
Yeah, I know we have a few in the audience that have never been through an SEC exam, so I'm happy to talk through some of the process. So when you are going to receive an examination, it typically starts with somebody from the SEC calling the CCO, so the named CCO on the ADV filing. You'll get the call and they'll say, thank you, you're being subject to an examination. You'll receive the initial request list shortly, and it's typically emailed that same day, maybe the next day. Your due date is generally going to be within a week. Pretty common to have a 2-week turnaround time. So if you're getting a very extensive initial due diligence or a document request list that may be anywhere between 20 items to 50 items, that's going to take a lot of effort to kind of get that turned around within a week or 2 weeks. It is often the case that folks will ask, can we ask for an extension? Can we ask for more time? And it's perfectly acceptable to ask for more time, but I generally try to get everyone to complete all the information. Let's try to work on getting everything so that we put the best foot forward in the start of the examination and kind of start the right tone with the SEC. That being said, you have to weigh that against the risk. You don't want to produce anything that you're not 100% comfortable with producing. So if you run into a situation, you're running close to the deadline, it's perfectly acceptable to ask for an extension. And the exam staff is usually very open to granting that extension.
And what about the role that the CCO plays in interviews? And so obviously that CCO is going to be interviewed by the staff, but a question we get is, should the CCO be a silent participant on the portfolio manager's interview or CFO? What role should outside counsel or the compliance consultant play in joining those interviews as well? So what do you see in the market?
So for the interviews with the exam staff, I usually will expect the CCO to, at a minimum, sit in on every single interview. And so if it's an interview with one of the portfolio managers, the CCO will be there with the portfolio manager and could potentially chime in if it veers into a compliance procedure or compliance process. We never want the portfolio manager to answer a question that he or she does not have firsthand knowledge of. And it's perfectly acceptable for the CCO to kind of step into that role. Peter, along the lines of your question, the role of a compliance consultant, perfectly appropriate to have your compliance consultant sit in on the SEC examination, particularly if the CCO does actually, in fact, rely on the compliance consultant for a lot of the support, day-to-day testing, implementation of nitty-gritty policies. That's definitely okay. You sort of have to weigh the risk against having a perception of not a very strong compliance framework by having extra third-party support, but we have seen that. What I do counsel generally against would be not having legal counsel kind of sit in on the interview. We want to set the right tone for the examination. And so once you kind of bring in outside legal counsel, it sort of ups the ante in terms of potentially having an adversarial posture. And so we want to set a conversational tone with the examination staff in connection with the interview.
Great. Well, in terms of a deficiency letter, the vast majority of exams do result in a deficiency letter. Depending on the type of manager, whether you're a mutual fund, it varies anywhere between 60 and 80+%. But ultimately, managers may receive a deficiency letter. So as we get to the conclusion of this webinar, would love just to understand, one, Mike, your thoughts as to, if I am a manager that received a deficiency letter, do I need to share that with Shadmore when they're doing operational due diligence? What are some of the things Mike and his team may be concerned about? And then, Ann, what are the expectations of follow-up from the SEC once I respond to a deficiency letter?
If I could start, I would say that the operational due diligence reviews are much more limited in scope than an SEC exam. We have a limited amount of time. It's usually hours. It's not days. The reviews go on for a few weeks, not for months. It's a very, very different level of depth. But what I would say is that the outcome, or the deficiency letter, is very important to operational due diligence practitioners. We know the SEC had more time and more, control and more jurisdiction and more document requests and the ability to dig a lot deeper than we did. So understanding what they found versus our limited scope exam is really, really important. The range of scenarios that can come from how a deficiency letter is shared is really quite broad. You have managers that are willing to share it, and some of them will provide you the letter electronically. Some of them will only allow you to review it on site. And then there's some that will not allow you, will only summarize the letter for you. They will not allow you to view the letter on site or electronically. And then there's a very, very, very small number which literally will just not comment on anything at all. Like, will not tell you whether they had an SEC exam, will not tell you whether there was deficiencies. So that's probably the rarest, and that latter one probably causes the most anxiety because it's so off market relative to peers. And then you wonder, well, if it's just so minor, why wouldn't you just share it? One of the things that I would just say for us is that so many of these reviews are conducted virtually now, especially prior to COVID. And when there are instances where the investment managers have said, we'll share the SEC letter with you only if you come to our office, we have found that in many cases that was worth doing because the SEC letter was different than our expectation as described by the manager. There's a lot of latitude the manager has when they describe the deficiencies versus you actually reading the letter. That sort of, I think, is a good way to think about all the different scenarios around it and how to manage the deficiency letter reviewing for ODD practitioners. But it's very important, and I think that I would encourage all the managers listening to try to be transparent about it and sharing of the letter, if not sending it out electronically, maybe through screen share.
Yeah, in terms of the process, it's very common where you would receive a deficiency letter, you have 30 days to respond to the letter, you respond to the SEC, and you may not hear back from the SEC. They may not say and send you a nice closeout letter. It's more common for you not to hear anything. There could be situations where you provide a deficiency letter, they actually don't agree with the way that you've remediated the particular finding, and they could send a letter saying they disagreed with the way that you've evaluated or resolved the finding. And that could be a scenario where, unfortunately, it could be referred over to the Division of Enforcement. So we have seen that as well.
And what about, I guess, two quick points. Well, Mike, on your point about managers sharing or summarizing the findings of a deficiency letter, I would caution all managers to be quite careful as to how you're characterizing that, given the representations that you're making to your investors or your prospective investors. So that's something you would want to be very pragmatic about as you're approaching that. And then as it relates and to the deficiency policy suggests that you enhance them, or how are you going to respond to that? Question we get fairly often is, should we just acknowledge that we're going to update our policy? Should we share with them a red line of a new compliance manual that we drafted as a result of that comment? What would be your thoughts there?
So our general approach is to share the actual substance of how you're enhancing a particular policy and procedure. We may not send over the entire compliance manual again, but the particular policy that they're focused on, we could excerpt sort of a red line showing the changes that are being made. I think that goes a long way in actually mitigating any follow-up from the examination staff. Once you send the deficiency letter, you don't want to hear from them ever again. And so I think that's part of a strategy consideration to have to deal with that.
So the last slide we have is simply on two related topics, self-reporting and whistleblower. So perhaps I'll just pause there and let the panel share a thought or two on that, and then we'll wrap this up.
So we're getting a lot of questions around self-reporting. It came up a lot in connection with off-channel communications, e-coms, whether or not there's any benefit to self-reporting. The SEC has been on the circuit touting the benefits of self-reporting. There's no legal requirement, at least under the SEC rules and regulations, to self-report a violation. We generally, of course, facts and circumstances would advise not to self-report, but if you're in an active examination, you do have to be careful of reporting the violations, because there could be a scenario where they've asked a question around compliance matters, compliance violations, and if you're in the examination process, you may need to provide that information. That's what I wanted to mention on self-reporting. Whistleblower protections, a cautionary note, the SEC is still looking at compliance with the whistleblower rule 21F17. Make sure any of your employment agreements, they are looking at fund agreements, and make sure you're not impeding any communications for alleged violations.
Yeah, and remarkably, despite the whistleblower protections and the focus of the staff on that via enforcement actions, we're still seeing enforcement actions pop up with violations of that rule. So important that we do remain focused on that. Apologize to the audience here for going over a few minutes. We certainly hope that you found this discussion helpful. We are quite passionate about discussing these various topics. So with you, if you have any one I'd like to raise with each of us, and many thanks to Mike and Ann for spending so much time with us today and sharing their expertise. So thank you all for joining us. And after this webinar, we'll be pushing out a recording of this to the extent that that you would find that helpful. But
thanks, Peter. Thanks, Ann.
Thank you.
Thanks very much. Bye.